All right, folks, cut to the chase. Your favorite podcast, our favorite featured guest, Mike Burns from Mostyn Law Firm, with breaking news: 3M earplug case, largest mass tort case in the history of mass torts. And this case has been litigated for 4 years. 250 some odd thousand veterans involved in this case with tinnitus, ringing in the ears, loss of hearing, maybe even both. All these trials, 3M trying to do these crazy bankruptcy maneuvers, all these appeals, nothing going right for 3M. I gave up thought on the hope of settlement, and then all of a sudden, Greg, you got to turn. Oh my God, the phone is off the hook, and it's Mike. What's going on? Give us the
Greg,
rundown. Everybody's
we
dying here.
Greg, we've got a settlement agreement with 3M. It's already inked, dealed, and sealed and filed, which is a great thing. A little over $6 billion to the plaintiffs in this particular case. It's going to be paid by 3M to settle all the claims. That's what 3M wanted, is they wanted closure. And that's what we're going to have with this deal. It's going to resolve all the 3M earplug cases. And that's what Judge Rogers wanted. She wanted a global settlement. That's what we have, is a global settlement with 3M. It's broken down with a lot of deadlines that I've sent you the copies of it. Maybe you can put that on your website so our viewers can see that and know that we're going to be under some schedule crunches, but at the same time, everybody's going to work real hard, be real diligent. I can't thank the leadership team, especially Brian and Stock and Justin Wickens for their hard work. Clayton Clark out of Clark Love and Hudson out of Houston, Texas. And of course, Chris Seegers, who many people know in the legal world, who did a lot of the concussion cases for the NFL. Those three were very effective in bringing this case to settlement and a global settlement like Judge Rogers wanted. And it's a good settlement. It's going to put some money in the injured party's hands, and some of it's going to do rather quickly, in the sense that, we've been going at this coming up with 5 years, started back in late April, early May of 2019. So, Greg, if you don't mind, I'd like to share with our viewers a couple different processes that are going to go on. There's going to be an expedited pay process. There's going to be a review process, and then there'll also be an opt-out process. Each one of those processes are going to have their own rules that apply to the process in order for these soldiers and servicemen and women to get paid. The first one, the expedited process, is going to basically have 5 categories, maybe 4 categories to pay. If you have tinnitus, but you don't have any, if you claim to have tinnitus, but you don't have any records of tinnitus, you can put in for that. That's going to be a $5,000 claim. That's what it's going to get paid for. The next one is if you have tinnitus, and it's documented, or if you have slight hearing loss, that's going to be paying out at $10,000. The next one's going to be if you have mild hearing loss, that's going to pay out at $16,000 a case. And then if you have moderate hearing loss, that's going to be paid out at $24,000 a case. So those are the expedited process. It's going to work fairly quick. There's going to be deadlines. You're going to have to make your decision on whether or not you want to be in that process fairly quickly. And we'll put the dates up on the website. Whether it'll be on your site, it'll be on the site for Mostyn Law, so that people can check out those dates. Also, we have a review process, which will allow you to have your case fully reviewed by the special master. And once he puts the cases on a grid and assigns point values to those cases so that they can determine how much each case is worth, and then opt-out process if you don't want to be a part of the settlement, if you want to put your case to trial. And there'll be a whole set of procedures that have to follow that. The judge has already issued an order to that. It's a CMO number 57. She's put that out. That went out early Tuesday morning. And so that's going to be another process. Also, 3M is going to have to pay the jury verdicts. That's going to come out fairly quickly. Hopefully, the first part of 2024. And also, they're going to have to pay the waived cases that are having to be worked up to go to trial, and that should be fairly quickly as well. And then the next thing is 3M. By us being able to get this case resolved, 3M's going to have to dismiss all their appeals. They're going to have to dismiss their appeal that we've talked about on the show many times on the government contractor defense. They're going to have to dismiss their case on the successor liability, and they're going to have to dismiss their case on the bankruptcy appeal. So overall, Brian Ilstock, Justin Witkins, Clayton Clark, and Chris Seegers did an excellent job helping to resolve this case for the men and women that serve our country and have been injured by these 3M combat arms earplugs.
And Bill Barr also, right? And
Oh,
yourself.
Brian Barr,
Brian
myself.
Barr. Oh, yeah, yeah.
And
And yourself also.
Yeah, I appreciate that. But
Okay, I want to break this
I
down.
know you saw each other the other night, so it's
Yeah, he'll forgive you. All right, so I want to break this down. Now, first of all, I don't know this myself, but how many of the 250,000 some odd veterans don't have attorneys? Actually, we're doing this on their own. A very
very, very small amount. I think at one point there were 2 people that weren't
Really?
represented by a lawyer. I know that group whittled down to 1. One of those guys was a law student at the time
Nice.
at Florida State University.
Nice.
So, but I think he actually decided to get a lawyer to represent him.
Good.
And,
Good for him.
and then there was another one that was unable to access a lawyer because of the situation that he was in. And so we told him that we would represent him pro bono. So that got it down to 0. So right now it may be, a couple more, maybe 5, maybe 10, but it's not that many people that are unrepresented.
All right. So for everybody else that's represented, you're going to basically be getting letter and information from your attorneys that you have to read, digest, understand, and respond to. And if you don't, or you just, you're out of the country, you're not getting your mail for months, you might have your case dismissed without getting paid. So people have got to pay attention to that fact.
That's very true, Greg. If you get a communication from your lawyer right now, which you will get, and at some point you're going to be getting communication from Archer, who is the settlement administrator, you need to respond to that. You're not going to, your cases are not going to get paid if you don't give your social security number, because you're going to have your social security number. Your case is not going to get paid if you have not, completed the DD 214 and you haven't completed the census. Your case is going to get dismissed. So whatever your lawyer asks you for, you can guarantee that the court has asked your lawyer for that information. If you don't provide that information, very likely that your case is going to get dismissed, and it's going to get dismissed with prejudice. And that means there's no going back. You don't get to go back to go and start over again. You're not going to get to fix it like we fixed a bunch of cases along the way. You're not going to get to fix it this time. That's going to be the final blow. So please stay in close contact with your law firm that represents you. If they send you information, whether it's via email, electronically, or in the mail, snail mail, whatever it is, do it. At some point, you're going to be asked to complete some forms. Those forms are going to be over what they call DocuSign. Greg, I'm sure that you use those at your law firm. And what that's going to alleviate is you having to sign a hard copy, because you're going to sign it electronically. And that's going to become the information that goes into the official records when it comes to releases. Everybody's got to sign what's called a release in order to get paid. Release 3M from the liability, and they pay you X number of dollars in your particular case. But you're going to have to do that, and you're going to have to do it in a timely manner, because Judge Rogers is as Greg, has run this litigation very tightly. This particular litigation, Greg, and you understand this, makes up 30% of the entire U.S. federal court docket. 30% of all the cases in the country.
Wow.
This particular litigation. So this is a big, big deal to settle this case. It's going to relieve a lot of space on the U.S. court docket throughout the country, and it's a good thing. And so I appreciate you doing the podcast and keeping everybody so well informed.
Yeah. All right. So there's a couple misconceptions I want to kind of flesh out before we get back into expedited, review, and waive and opt out. Okay. Those are basically the first four options. Now, so out of the 250,000 people involved in this case, veterans, I'm sure there's been a bunch of them that have actually had other lawsuits. Maybe they got into a car accident or slip and fall or whatever, and their lawyer calls them up. The case is settled. And, then they were getting a check in 30 days. They're signing a release that basically says they're not going to sue anybody for it anymore. And that's the end of the ball game. That is not what's going on here. Okay.
That is correct. That is not what's going on here.
Anybody is sitting here thinking, I'm getting paid quick and I'm getting a check quick. You're not. It's probably not. Now, Judge Rogers has set forth these deadlines. And you, like, as you've told many times, this judge is a no nonsense, efficient speed merchant of probably the first degree. So she will move this fast. But if there's anybody thinking, oh, I'm getting a check in 30 days, forget about it. Okay. You're going to have to do what your lawyers tell you to do. And you're going to have to basically make a decision whether you want expedited, the review process. Maybe your case was one of the 2,000 or so cases that the judge sent out on, we call it a wave. I know Mike, surfs waves. He's gotten hurt. I've told him, don't go back. And he goes back. That's not the wave that he's talking about. That means your case actually got sent out to the court that it originated to be set for trial, because the judge basically was throwing up her hands, with the fact that 19 cases were tried, 13 victories for the veterans, but there was still no settlement. So she said, okay, I'm sending it back to the originating courts, and those judges are going to set those. Those are the wave cases. There's 2,000 of those. So let's just talk about that particular, if your case is a wave case, how do you know your case went into that wave? Or will you, and are you going to have to go through the same process of filing paperwork and all that?
So if your case was a wave case, if your case was selected to be worked up for trial, you have already talked to your lawyer, because your deposition has been taken. Your client's deposition has been taken. Your case has been prepared, expert reports and all those things. So you've been in close contact with your lawyer if your case was a wave case. And those cases are in there's a separate group of rules that apply to the wave cases, just like there's a separate group of rules that apply to the cases that have already been tried and the verdicts. Those cases will take priority as far as getting paid first. And then, like I said, then the next group will be the expedited cases, then the reviewed cases, and then the tail will be the opt-out cases. There's also a program, Greg, that people will be eligible for if they have documented hearing loss and tinnitus, which is called the EIF fund, which is the emergency injury fund, and the special master will, after he's graded everything else, that'll be, once again, that'll be at the tail end of things, where he will assess the value of the case and whether or not there's additional funds to be paid to that particular plaintiff, because their circumstances are extraordinary, their injuries are extraordinary, and they deserve some extraordinary.
Okay. So we'll hold that to the end. All right. So the expedite. So you're going to get a notification from your lawyer, got to fill out DocuSign and all that. And you're basically going to be presented with three options.
Correct.
The expedited review, meaning you're going to get paid a little earlier, but we're talking probably, a year to 2 years from now.
Yeah, I would say it's going to be a 12, 18-month process for the expedited funds.
And you're going to get less money if you do that. Well, you
You're
really
right.
might not have any choice because if you got tinnitus and it's not documented and you go through the review process, I mean, you're gonna
Well,
have to talk to your lawyer whether that's a good move or not, but
you do, Greg. And but the thing is, if you have tinnitus and you have no documentation, you're going to be pretty much pushed into that category of the $5,000 because you have no evidence to support um, that you have tinnitus other than your state. So that case is valued at $5,000, and
okay.
that's going to put you in that category. So if 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 you claim that you have tinnitus and there's no documentation anywhere in your medical records that you have tinnitus, then you're that's where the wall is going to be for you, and it's going to be 5,000. You're not going to go over that wall, so that's where you're going to be. The next class would be tinnitus. It's documented, but there's no hearing loss or anything else. So that just puts you right there. So that's going to put you in that particular category up to $10,000. Now, you may be eligible for the EIF, the Extraordinary Injury Fund, but you might want to talk to your lawyer whether or not you're going to pursue the review process if that's all you have is the tinnitus, and it's just mentioned to the doctor, so it's in your review that there's no other injuries. Then, of course, then it's going to be hearing loss slight, hearing loss mild, hearing loss moderate. That's going to be 10,000, 16,000, 24,000. Those cases are eligible for the expedited pay, and they're also
Now,
eligible for the extraordinary injury fund at the end of.
all right, so you could select expedited and preserve your right to go through the EIF
That's
process.
correct. As long as you meet those threshold issues. That's correct.
All right, so the next level is the review where your records, you have to have medical records are gonna get reviewed by the administrator, and they're gonna make a determination of whether you qualify for a higher level, or how does that go?
So let's say, for example, you have hearing loss and you had your threshold tests, and what you can pick a date, let's say 2008, and there you are. And then you get a test in 2009, and there's a shift. You get another test in 2010. There's a shift, and onward. And those shifts are let's say 10% bump, bump, bump. So it keeps going up. So in that particular case, you've got the medical records to indicate that you have hearing loss, and you have continued, um, your hearing losses continued to worsen over the years. That's the case that you want the special master to review. It's in your records. You see it in your records. That's the case that you want to be in the review process for. And then what happens is the special master will take that particular case and he's going to put it on a grid. Let's say the grid's going to start at a dollar value and it's going to go up to a dollar value. And then what he's going to do is he's going to assess points to your injury. For example, if you have hearing loss in your left ear, he's going to assess and he looks at the audiogram and you have the audiogram, and let's say you have 4 or 5 audiograms and it shows the progression. So he's going to add those points up for your left ear. Then you're going to have hearing loss in your right ear, and he's going to look at maybe that's say let's say you have 3 levels of progression in the left ear. So let's say that adds up to 3 points. He gives you a point for each progression. Same thing on the right ear. The right ear, you have only 2 points. So he gets that. Now you have a score of 5. Okay. So he's going to take that, he's going to scale everything, going to put 5 on the scale. Let's just say the scale's 1 to 10, just so we make it very basic and we understand. So there you are. You're going to be halfway up the scale, not towards the bottom, not towards the top. You're going to be in the middle. So at the same time, at the end of the day, if there's any money left over at the end of the day, it's going to be divided equally to everybody based upon the points that they had on that scale. So the guy at 5 point, all the guys at 5 points are going to get the same level. All the guys at 2 point are going to get the same level. All the guys at 7 point are going to get the same level. That's how he's going to do it if there's money left over at the end.
Yeah,
So
but it'll be more than the 24,000.
it'd be more than 24. Let's just say that whatever that is, it's the starting number.
Okay.
Because you're not going to be in that category if you're not going to be in that category if you are um, more than um, slight hearing loss, right? Because you already opted out. Okay.
Yeah.
You can have slight hearing loss and still be eligible for the review process as well as the EIF at the end. But then you wouldn't have taken the expedited process.
Yeah.
You with me?
Gotcha. So let's say you go through the review process, you disagree with the points. Can you appeal that?
Well, you can accept it. Usually, what you can do is you can accept the amount and then you apply for the EIF. Is
Okay.
what you do.
So the
Okay.
EIF is essentially like almost like an appellate process.
That's what the EIF is basically. You take what you get and then you request extraordinary injury fund, the EIF.
Gotcha. All right. And then the third option, you had the expedited, you had the review. And then the other one is like, hey, you know what? I see these people are got these $50 million verdicts. I want to take a shot at it. You have the right to opt out. You're not going to settle. You want to go forward.
And you're going to need to
Opt out.
you're gonna need to talk to your lawyer about the opt out procedure. I'm just fanning through it right here. There's at least 10 pages of of, of a PowerPoint describes the opt out policy, what you're going to have to do, um, how your case has got to be transitioned within 14 days to the active docket. There's all kinds of requirements that you're going to have to do. Your lawyer will go over those those requirements for you, and um, that will be at the end of the day. The judge will um, do the same thing, probably like she did with the other cases. She'll send that back to the trial court judge, wherever that might be. She more than likely are going to come in and have you speak with her directly, and she's going to talk to you about your case because she's going to know about your case. But your lawyer, the individual lawyers will that represent the clients will go through all three of the procedures, and that procedure in particular to let you know whether or not you should go forward with the opt out procedure.
Yeah. Now, my understanding is if you do say to your lawyer, I want to opt out, your lawyer can at that point say, you know what? I don't want to proceed any further as your lawyer. I think you should take this settlement and goodbye. I mean, that's
You-
that is a distinct possibility. And then you're going to be left scrambling around to find another attorney with all these deadlines. You don't meet the deadline, you're done. Case dismissed, no refiling.
That's correct. Your lawyer's going to have the option to opt out as well, opt out the representation as well.
Okay. So the other misconception, and I think by at this point, most people will understand it, is I think a lot of people were seeing 6,240,000 veterans. They did the math and they're like, okay, I'm getting $25,000. That that's not really how it's going. As you can
But
see,
how it works.
you might get
But
zero. You
that
might
may
get,
have worked in other cases such as a class action. That's what's different between mass torts and class action. So, I mean, we'll just make the distinction. A mass tort is based upon your personal injury. That's why you are a personal injury lawyer. You represent that individual. And that's what mass tort is. You had to file an individual lawsuit. Class action cases, everybody gets the same amount of money because everybody has the same injury, not the same in a mass tort. There are, as you see, that's why there's different amounts that are assigned to the value of somebody's injury because the injuries are different to a different level.
all right. Now I tried to keep up with all the information that's being presented to me, and I kept hearing 98% have to approve. 98% of the veterans will have to approve it for it to be a done deal. But you're telling me that's not really the
That's
situation.
not that's not the truth. 98% have to participate. They don't have to approve. They have to participate. And then once that we hit those numbers, then 3M has to fund the the settlement. And
Oh,
like if you want to, there's three different ways that they're funding the settlement. One is from insurance proceeds, a little over $1.5 billion in insurance proceeds. $1 billion in stock, which will be converted to cash. So what happens with that is um, 3M will have to, on certain dates, transfer the stock to us. That stock will be sold and based upon a 10-day average of that stock and exchanged for cash. So that number, no matter how many shares of stock it is going to equate to $1 billion. So we get $1 billion, basically their stock um, transferred into cash, and then the balance of that is cash from 3M.
All right. So I'm just going over my notes here to make sure I covered pretty much the whole thing. And I think it was, that's enough information. I think, listen, everybody, this is not legal advice. You're going to be talking to your lawyers. Don't ignore what your lawyer said. Oh, I listened to this podcast. I know what I'm doing, blah, blah, blah. No, you got to hone in. The case is settled, but it's conditionally settled. You're only going to get paid if you do this. I guess my last thing is the expected time frame for the expedited is 12 months to 18 months. The review you think is two years?
Couple years, 2 to 3 years. Could be longer. The tort lasts for a period of 6 years. So we expect it to all be completed by August of 2029.
And a lot of this is just pretty much
the month. It could it could be sooner, but that's the end date. So there's a list of dates, and I sent you those, and you can put them out there so that people can see, what the schedules are, and how we have to perform on certain dates, and how the money is transferred over so that the payments can be made to the soldiers.
All right. Now, so I think that pretty much wraps it up. I just want to say, Mike, you've done a fantastic job, and you've always been very friendly and accommodating. Anytime I know there's a break, an update, and I know I have a bunch of lawyers that, are sort of dependent upon me to fill them in. And so this is my way of filling them in on what's going on. So I truly appreciate it. It's a great day. I think, the fun just starts. I know, Judge, these dates are going to be freaking some people out and oh my God, what do you mean 6 years or whatever? But Judge Rogers is going to be putting the heat on these administrators, and the money is there. It's not going away. It's going to get done. Follow your lawyer's advice. If you're not sure what your lawyer wants you to do, call your lawyer again and make sure you got it right. They got to properly advise you. If you don't really understand and you need a few times talking to them, definitely do that. All right. Anything else, Mike, that you want everybody to know?
It's been great, and just have thoroughly enjoyed and continue to enjoy representing these U.S. Soldiers, men and women that have served our country. And it's just been a great day to be able to get justice for them, and look forward to continue to work with them and for them throughout this process. Thank you so much, Brett.
And we'll probably have an update, at some point, just to give everybody an update on what's going on. But Mike,
Be glad to.
you got a lot of work to do. All right. I got
Lot of
to put the show notes up, which is going to have all these schedules or whatever. But anyway, God bless you and all you've done for these veterans and the court system and all that. And get back to work is all I can tell you.
Okay. Thank you, Greg. Thank you, Mama, said I.
Of course, of course.